on the two motions that are pending in the case.
In summary, the City of Cumming's defenses and those of the mayor in his official capacity are based on sovereign immunity and a lack of waiver. The statutory construction argument that by its terms, no civil fine is authorized against the City of Cumming. And then for Mayor Gravitt individually, his official immunity bars the action against him because there's no injury or damage alleged in this case, and because there's no actual malice or actual intent. Either one of those alone, under official immunity, is enough to bar this action. With that,
have you ever come across any action in Georgia or any other state where there was a claim for injury or damage related to an open sunshine or open meeting enforcement?
I'm not aware of one, although I can tell you one has been brought. The plaintiff in a Northern District of Georgia suit, Ms. Tisdale, the one who was there on the night in question, and the one upon who the Attorney General has brought this case, has sued the City of Cumming in federal court. We're in front of Judge Story right now, where she's claiming injury or damage. It's a 1983 action, but they've also included allegations that we violated the Open Meetings Act. But it's a 1983 action. But it's not an identical situation because, of course, we take the position, and I'll get into this later, that Ms. Tisdale was not removed from the meeting. But it's the closest thing I can think of right now, aside from the civil action in front of Judge Story, the Northern District of Georgia Gainesville Division, where we now have an action where Ms. Tisdale has brought a 1983 claim against the City of Cumming.
Okay.
Unless the court has any further questions from me, I'll sit down and drink some water.
I think I've exhausted you and me both. Let's take a 15-minute recess. I have, let's call it 11 o'clock. We'll start back at a quarter after.
Thank you, Mark.
Could it have been meant, though, to single out that one hard-headed person who keeps right on closing the door in spite of the fact that the law clearly says he or she should not do so? And could it be restricted to that person as opposed to punishing the taxpayers of the entire municipality? Could it intend very clearly to address the conduct of the person who either is so carefree and negligent that he or she doesn't learn the law and apply the law, or is so bullheaded that they continue to violate the law? Are there other cases, enforcement cases, handled by your office that are currently in litigation or in the process of appeal?
No, Your Honor, you're not. And to be quite honest, there are very few that ever have to be brought because most litigants will try to resolve this with a short of a lawsuit, and that was not possible here.
Okay. All right, what I'm going to do is take a lunch break and then address the summary judgment issues. But before we do that, let me do a little housekeeping of my own. Have there been any issues to resolve this case by compromise?
Absolutely. For 2 months following the incident, there was an extended dialogue.
Why don't you stand up and come up here too, Ms. Powell? Let's talk in terms of what is your assertions as far as evidence to compromise this case?
Well, I don't think the defendants can dispute it, but there were, the office handled as they do any allegation of a complaint, a letter asking for an explanation, and, you know, it was attempted to be resolved.
Your Honor, if Mr. Miles and I can address the court, I'm stepping in.
Sure, I'll
Yeah, they
let
don't
you
want-
all go wild on this.
Okay. Before Mr. Talent and Ms. Campanella were involved in this case, I think that Mr. Miles and I are both the superiors of our relative people who are speaking today, and we spent some time trying to resolve this case. And we had a very cordial relationship in trying to do that. I won't go into all the details. I will tell you, unless there's any problem with that, that I think that the sticking point was that the Attorney General wanted an admission of violation of the law in this case, and the other side was not willing to agree to that. And I think the reason is because they were concerned about that being an admission against interest in future cases, and certainly they vigorously contest liability. So that's where we are on settlement. Often I don't discuss settlement with the court, but I want you to know that that's the situation, and I think that if we could agree that it was not useful in any other, usable in any other proceeding as an admission of liability, we probably would have been able to come to a resolution.
I would concur with what Mr. Ritter said. The sticking point was the Attorney General, not Mr. Ritter, but his boss, insisted upon an admission of liability by the city. My fear was that that would be used against the city in a lawsuit by Ms. Tisdale. She hadn't filed the suit at that point in time. The Attorney General's office opinion was that she didn't have the right at that time to file that suit. She filed it anyway. We currently have pending against us exactly what I predicted would happen. That's why we were not successful in resolution. The other matters I think we could work through and did work through fairly successfully, but the sticking point was it requested an admission of liability. And the city was unwilling to do that, and therefore, because of potential for collateral
Is there a
third-party suits.
distinction between an admission of fact versus an admission of liability?
There could be, Your Honor, but in this particular case, the discussion as I understood it was they wanted an admission that the city and Mayor Craven had violated the Open Meetings Act. And so if you admit to those facts, that in essence is an admission of liability.
Well, that's exactly where we're headed with the motion for summary judgment that's filed by the Attorney General. If, as I understand it, upon any of the three allegations, there is an undisputed allegation of factual sequence which constitutes a violation, then this court is going to have to rule that there was in fact at least a violation. So what are you doing if you're admitting, if you're going into this afternoon session without a defense on any of one of the three different avenues of violation? Why not go ahead and settle the case and let the federal court deal with all these issues of sovereign immunity
Instead of, Your Honor?
instead of me having to do it with? I mean, we're not talking about mountains of gold here. We're talking about.
That's right.
We're talking about doing what counsel tells me the city is already doing, and that is having a carefully defined, well thought out regulation by which any citizen can be safe in a meeting with recording devices or video cameras or anything else. And we already do that, I'm told.
I'm told that's the case too, and that being the case, we're delighted to see that came out of these negotiations and ultimately lawsuit. And we, frankly, from our perspective, our feet were sort of put to the fire. They called us and said, "Why don't you file a lawsuit because we're not going to admit to liability?" I'll tell you, Your Honor, I don't want to get into the summary judgment issues, but they acknowledged this morning that no one disputes that she was ordered to stop recording. We see the text right there, and.
All right,
that's not mountains of
let me
gold.
leave y'all with something to talk about at lunch. I've read almost everything I think that's been provided in this case. Now, I have not seen the movie, but I don't think the movie adds anything to the lack of evidence on the city side. It looks very clearly to me at this point like there is no dispute over the fact that the citizens' right to record and to take video within the meeting was violated. And there has been no reason given, which is your responsibility on summary judgment response. There's been no reason given which constitutes a defense to that violation. I mean, the others are very clearly, at least at this stage of my knowledge, disputed facts. You know, I don't know whether she left the room or didn't. I don't know whether she was thrown out or wasn't. I don't know whether she was, it's disputed even that she was told by the mayor or by anyone with real authority to stop the second recording session. But if we admit that she was stopped her effort to record, and there was no excuse of disruption or interference with sight line or noise or anything else, and it hasn't been asserted, aren't we already in a state where we've admitted liability on one point of the complaint? Think about it. We'll talk about it this afternoon. Y'all talk. Eat lunch together.
Yes, sir.
Be in recess until 10 minutes after 1.
Thank you, Your Honor. I don't know what my boss.
Kelly. Never mind.
No handshake from the mayor. He didn't want to check.
I'm sorry if I misread.
That's okay. Yeah, we just saw the
Okay. Okay, I'll clarify that one. I'm sorry if I misread. I just was trying to roll with it.
good job.
That's some good Mexican.
Well, this is
How's trout fishing been lately? Really? Oh, wow. I got
All
out
right.
to 2 degrees.
Come to order.
good.